Gregg Wilkerson.
Well, thank you so much for that. I want to take you guys down memory lane in some ways, or introduce you to some things you may not have known about. Having been a government guy for a good part of my career, I guess the main point of my talk tonight is that there's science and there's government, right? And never the twain shall meet. So it was always sort of a interesting career dealing with the politics of science as it relates to mineral management. And as an illustration of that, I want to share with you stuff that I did from 82 through about 89, when I was in this program of lease classification and oil gas management for California. So the Mineral Leasing Act was a big change for the way minerals were managed in the United States. Prior to that, there were a series of mining laws that sought to regulate minerals. And the 1872 mining law is still in effect. It's been highly modified. But this developed after the Civil War, but really after discovery of gold in California during the gold rush. And the California gold rush and the way that the miners in California self-regulated themselves. They formed mining districts. Mining districts passed rules about where claims could be, and this really influenced, clear up today, how we manage minerals. But basically, back then, there were quartz veins and then everything else. And where does oil and gas fit into that? So this was a real change in 1920. Before that, these were homestead acts. And if you found mineral out there as a reward for your trouble, you could patent the land and get the surface rights and the mineral rights, lock, stock, and barrel. And you pay $2.50 an acre, and $5 is a kind of a processing fee. But it's an outcome of really English procedure where the Crown would give concessions to people willing to take risks. So this management really for oil stems back to 1866. And then there were a series of legal decisions and policies that applied to oil. The Act of 1897 addressed this issue of oil and gas and basically said that any person authorized to enter under the mining laws for petroleum or other mineral oils, you could do that as a placeret. So I want to talk about the difference between veins and placers. But this era is well illustrated in this great show, Let There Be Blood.
I'd certainly appreciate it if you didn't waste mine. Now, if you wish to sign with me, we can have well drilling within 10 days. Your lot is further north from the discovery well up here, and so, well, that means we'll probably have to dig deeper. And if there's as much oil here as I think there is, it'll be harder to reach. Once we find it, we can take it right out. We have to act quickly, because very soon these fields will be dry. So, I need you to know what you want to do. Now, because of the distance from the discovery well, I'll pay you a smaller royalty than you'd get down there, but I'm prepared to give you a $1,000 bonus on your lot.
What kind of royalty are you talking about?
1/6, plus a guarantee to start drilling within 10 days. Now, that's something you won't find anywhere else.
Coming in, boss!
Okay, how many of you know about Let There Be Blood? Any of you? It was I got an Academy Award for the main actor there, but it shows the situation there. And how do you, in order to get your patent on these on these oil placers, you had to prove discovery, and discovery was proven by if you had a gusher. You know, you put your dig down with the shovel or later cable tool rig, and if you hit the gusher, you qualified and you got your 20-acre claim. This application of placers stems from our third president, Thomas Jefferson. He established this system of describing land throughout the West. It doesn't apply to Texas, and it doesn't apply to the original 13 colonies, but everyone else uses this public land survey system, which is the township, range, section, quarter section. It's sort of a Byzantine program. You know, if you got something up here, it's the northwest of the northwest of the southeast of 14, but that's the way legal descriptions are made, and that's how you describe your patents applications. Veins were 600 by 1,500 feet, and you staked them with a post in the ground. You had to have a discovery marker, and then you're limited to the size of the claim. These are the claims in the Comstock load, and they're on top of each other, and then this was fertile ground for lawsuits about who owns what, and there's a bunch of mining law related to basically it's first come first serve, but if you had apex rights, you could claim down dip extensions on later filed claims. The very first oil placer was issued out of the LA Basin on May 10th, 1872. Notice this is before the 1870, right after the 1872 mining laws passed. So this is Los Angeles district, what it was like back then. So discovery of mineral deposits for hard rock, it was an assay. You basically take your rock in to the general land office with a certificate from an assayer. And if the assayer had a good value on it, the guy in the land office said, well, that looks like a good claim to me, and get your land. This is the Lakeview Gusher from 1910 that 9 million barrels of oil was jettisoned out of that thing. Well, that's a discovery, right? Forget the environmental effects. So basically, you can think of quartz veins are autochthonous, placers are allochthonous, they moved in, and describe these by meets and bounds or survey, and these by legal location. So this, I ran into this in my career. We had some claims up. This is the little oil seep there at McKittrick that many of us here in the valley know about. But there was this claim here up in the reward area of McKittrick Field, and it's right there. And notice that the land around it is got various patents on it, but not that one. Well, what happened was there was a mining claim on that thing, and it was located in 1897. So there in 1885 or so, and this is 90 years after the claim was located, they had some wells on there that needed to be abandoned. But there's no lease, right? It's just a mining claim. It's an old oil placer. So what happened was the office sent Chevron owned it. So Chevron, told Chevron, you have to file a mining notice under our mining regulations to take care of that well. And make a long story short, they just abandoned the well by state standards and then let the claim lapse. And then after that, BLM tried to release it. Well, during this time of this transition between claims and leases, there was this interest in naval petroleum reserves. And President Harding here, they wanted to set aside these oil reserves. And this effort really started in 1909. And so these oil reserves were established. Two of them were here in Kern County. Elk Hills was Naval Petroleum Reserve number 1, and Buena Vista Hills to the south of that was Naval Petroleum Reserve number 2. Now notice up here in Naval Petroleum Reserve number 1, there's hardly any federal land. That's because it belongs to Occidental. Then Oxy bought it for $3.5 billion, and now CRC. But there, Buena Vista Hills down here, this other anticline, that's just administered by BLM now under leases. The other Naval Petroleum Reserve was in Wyoming in a place called Teapot Dome. Now, where have you heard about Teapot Dome before? Any of you know about Teapot Dome scandal? Well, what was happening during this time was this was the kind of the highlight of U.S. imperialism, and Teddy Roosevelt here put together this after this thing called the Great White Fleet in between 1907 and 1909, and this was a show of force. By then they had built these big old battleships, and they're sailing all around the world, showing everybody how great and mighty the U.S. is. Well, it was kind of an embarrassment because what did they use to drive the boats around? They had to use coal. Where'd the coal come from? Well, they had to go to Ghana and South Africa, these undependable countries to get their coal. And that set into motion a switch for the Navy to be powered by oil instead of coal. And so the Navy wanted oil. They want lots of it. And they didn't want to have to compete with the private sector for the oil they needed for the Navy. And so that's why the oil reserves were made. And then they packed this thing called the Pickett Act, which also established the Forest Service. And it was based, and this is what it was based on, this challenge in the Supreme Court here. And these reserves were judged to be legitimate or authorized under our Constitution. And so this interest in leasing, though, is we're kind of following this antitrust era, where there's this this ongoing feeling of the big companies are too big, we need to level the playing field. And so what they did with the leasing was they put in a two-tiered system of leasing that lands that are high potential would be leased competitively to the highest bidder, but the lands that were wildcat or unproven would be first come, first serve. Just come up and apply for the lease. Now, if two guys showed up at the door of the land office at the same time, the same day, then they had a lottery. So this lottery system got into effect. And of course, who's going to administer all this stuff? They're they're formally mining claims, so they're run by the Bureau of Mines. And this got initiated under Roosevelt, Theodore Roosevelt, but Harding kind of took it over. And this Harding had a guy named Fall, who was the Secretary of Interior. And then Fall got talked into giving it to the Navy. And those responsibilities later were transferred to the Department of Energy in 1977. Well, the problem with the implementation of the Leasing Act was tied into these oil reserve things. The Teapot Dome scandal of 1921 is the story of the rise and fall of Albert Fall. Albert Fall was the Secretary of Interior. And he had a couple of good buddies, one named Sinclair, Harry Sinclair and Edward Doheny. And these guys gave a bribe to Secretary Fall here to let him have these lands in his what is now the reserves for a loan of $100,000. Now, $100,000 is a lot of money back in 1920. It was a lot of money today. Well, what happened was this guy Fall just started having these lavish parties, and he was living the high life. And there was an investigative reporter that kind of looked into it and uncovered what was going on. And so, at any rate, the leases were canceled. But this leasing scenario, the land should have been leased. Okay, it wasn't leased. He gave it away as over-counter releases under the bribe. But what he should have done is leased it. Now he could have leased it two different ways, either competitively or non-competitively. Well, how do you decide that? The law says that you have to lease competitive to the highest bidder if the land is within a known geologic structure of a producing oil and gas field. Well, what the heck is a known geologic structure of a producing oil and gas field? Well, in a classic anticlinal trap here, the limit of the trap would be the oil-water contact, right? So the Geologic Survey in 1959 came up with a circular. And they said, okay, so here's an oil field. You make a map, you identify the oil-water contact, and then you draw little boxes. You can't use a natural definition. It's got to be administratively legal subdivision to conform with Thomas Jefferson's legal land survey. So that this little square boxes around here, that's why the KGSs as administratively follow legal subdivision, not geologic boundaries. So these are the known geologic structures in California at the end of the program. They're in about 1992, finally came to an end. The green here shows where the fields are. So you'll notice there's no correlation exactly between the fields and the KGSs. And then the distribution of the leases, that's just where the leases are. Why is there not a good correlation between the field boundary and the known geologic structure? Well, it has to go with because of the way that things were identified. And what was happening there when I was working in the 80s, there was a pressure to change the law. They didn't like this arrangement of the lottery system because a lot of people were getting rich off the lottery, and that should have been going to the US for bonus bids. So there were only two of us at the time in Bakersfield, and we had a reviewer in Sacramento. And so we were told, Gregg Wilkerson, I want you to go out and study these leases, and I want you to bring, the answer's got to be competitive leasing. We don't want this over-the-counter stuff. And said, well, sir, you got to have some kind of geologic rationale for the geologic report, don't you think? Yeah. Well, go on and do it anyway. So I'll give you an example here, this OXNARD field. Now here's the naval base, they're at OXNARD. And there's oil country there. And so the red here is the OXNARD field and the remnant things there. And now the base is down over here, right? So somehow you got to tie this in over here because we want to lease that thing competitive. And so what happened was there was this lease application from these guys. And so we had to proceed with leasing it. So again, this gets back to this lottery system. And there in the 60s, 70s, and 80s, there was a whole industry of buying and selling these lease applications. And so here's an example of it. And in Bakersfield, talking to the guys here, these landmen would go around town signing up people to enter the lottery. They wanted to get into the lottery. And they were getting a percentage of this, and then the winning lottery ticket could be turned around and sold competitively to the highest bidder. And so the government guys are going, wait a minute, that money ought to be going to the treasury, help everybody else. And we don't need to be in the lottery business. So that was the kind of the social setting of the whole thing. All right, so let's go back to the OXNARD field. So that's out here in the OXNARD basin. And there, it's an interesting field because it's got this cap on it. It's a tar seal, a little different. And I'm going to take you through Yeats's report here of it. So down here in this stratigraphy, you see this thing here called the Vaca sand? It's got a tar saturated. See, so this Vaca sand it's not a traditional clay layer over the sand. It's tar, and the tar, because of the chemistry of the oil and the water, it turns out that the oil actually doesn't float on the water. The oil sinks in the water, and so you have migration of oil both up and down. But basically, at this Pleistocene-Pliocene Miocene contact is where this tar formed. And here's the Dogger report of the it's fractured and so forth. But basically, it's the Pleistocene tar, Miocene tar. All right, so you got this tar seal. So these are some cross sections of Yeats on explaining the field. So here's this Vaca sand, it's right there. These are the well logs. And so the red here is the tar. And you'll notice that in some wells, the tar is a little bit above the contact. In other wells, the tar is a little bit below the contact. It's reflecting the fact that the migration of the oil is both down and up to form that tar seal. And these are just other cross sections through it. And faulting, these are the Conejo volcanics. Oh, by the way, I forgot to mention those. They got Conejo volcanics over here. Formed a basis to the basement of the stratigraphy there. Well, all right. So here's the Vaca sand, all right? Now notice this isopac, it's 0 feet here, right? Well, this is miles from that. This is miles from that Port Hueneme. Not to worry. The guy's name was Ken Holden. And so Ken Holden decided, and wrote a report that said this area here in these wells all showed tar at that stratigraphic point between the Pleistocene and the Miocene. So see that little well right there? That little well's right on the not the lease, the Port Hueneme. So based on that analysis, reports said, well, this has got to be the KGS. So what happened was they rejected the application, and it was appealed, right? You can appeal everything. Well, the appeal went to Interior Board of Land Appeals, and the judges there ruled in prejudice for BLM, which means not only did the Hamilton brothers lose, they lost big time. And what this meant was that BLM geologists could use our flights of fancy and come up with a reason to make these things big, these classifications big. When that happened, this opposition to the Leasing Act sort of crumbled and the law was changed. The other thing that happened during this time is we discovered, the land people told us, you guys got all these mineral rights up in the gas country. And they're not big areas of land, but they're over wide areas. Why? Because the ditches and canals. When the government gave away all this land for the agricultural development, they reserved ditches and the canals. And then it was decided that the reservation extended to the minerals. Now, the original patent didn't say minerals, it just said we're going to reserve the ditches and canals. But somebody in the administration decided it meant minerals, and then the courts upheld it. So I spent a lot of time looking at gas country in my early career because of these canals, so we could classify them as within known geologic structures, lease them competitively, and then we actually got some pretty good money off those little narrow leases, and then those were communitized. This is an example of the Dutch slough field in the gas country up there. So this was really precipitated by this other program we had, which was concerned for drainage protection. Now, how many of you guys out there know about drainage? Right? You run into that. You gotta protect yourself from encroachment. And we have this unusual development from really English common law that if you have a well and you suck all the water or oil out from under your neighbor's property, well, that's okay. That's just good business. And if the other guy on the other side of the line is stupid enough not to put a protective well in, that's his problem. So anyway, we had about 6,000 wells or leases that we thought were in this situation. You know, the company would buy a lease, surround it by other leases, and then drain the lease to avoid paying federal royalty. So I need to bring back Let There Be Blood.
God is a superstition.
Those areas have been drilled. Those areas have been drilled.
Oh, they haven't.
Yes, it's called drainage, Eli. See, I own everything around it, so of course I get what's underneath it.
But there are no derricks there. This is the bandy tract. Do you understand?
Do you understand, Eli? That's more to the point. Do you understand? I drink your water. I drink it up. Every day, I drink the blood of lamb from Bandy's tract.
So drinking the blood of the lamb from Bandy's tract, well, that's what drainage is, right? And so it was interesting. We looked at, there's 6,000 cases or so, and we ended up, at the end of it all, we think we drilled 3 or 4 wells. the oil companies aren't going to let oil go to somebody else, you know. It was, but I got to tell you this story now. You guys all know about fracking, right? You guys think fracking's new? It's not. We were thinking about fracking back in the 80s. And here's how it worked. We knew that Yeah, most of at least in the onshore Monterey. Now, offshore Monterey is fractured, right? But the onshore, really, you're looking for the Stevens type sands, right? You're looking for those turbidites that are coming down into the Miocene basin, and they're sinuous. And anyway, you want to hit that sand, right? The shale is sort of a consolation prize. Well, we noticed this behavior of all these wells, and that back then, we were permitting 1,000, 1,500 wells a year, and so we'd see all these guys come out and drill these wells, and then we get high initial production, and then we have a rapid decline, water out, and then they'd have these frantic attempts to acidize and refracture, and then they'd abandon over and over and over again. And what the heck's going on there? And so now fracking, you go down there, the fracking that's under such scrutiny these days is not, as you know, and that's not generally the type we do here in California. We do more vertical fracking, localized stuff, but the principle is the same. Is you throw a little sand grain down there and into that fracture, and prop it open, and keep it open so maintain your porosity and permeability. Well, one well came to my attention particularly, and it was this Dustin Protocol 122. And what was interesting about that well, it was drilled on a syncline. Now, a syncline, guys, they drilled on a syncline. And then they drilled it at 13,000 feet. They produced 40 barrels a day, watered out, they abandoned it, they went bankrupt, the regulatory people attached the bond. They went out 6 months later, this well, to abandon it, and there's 6,000 PSI at the wellhead. 6,000. So they had a cavity shot, and the thing started to flow. So it flowed 150 barrels in 2 hours, which is equivalent of 3,000 barrels a day. Well, 3,000 barrels a day, that's a money maker, right? Even back then. Well, they forcibly killed the well and went on to other business. But I got thinking about that. What happened there? And so here it's Dustin Acres between Naval Petroleum 1 and Naval Petroleum 2. And this is this structure there. Here it is, right on near the axis of the syncline. Why drill on the syncline? I think because the fractures are there. We're looking for the fractures. And what are the fractures? Well, why did fractures some places and not others? Well, to understand that, you got to go back to the lithology of the original Monterey material, which is siliceous shale. Why siliceous? Well, it's diatoms, right? So it's this interplay of diatoms and shale in the mix of the proportions that affect the temperature and depth and degree that fracturing will occur during tectonics and folding. So I kind of went back, well, you got to go look at basic rock mechanics. And so if you remember this from your structural geology course, Dr. Sylvester's with us tonight, and he'd love to remind us that this is structural geology. But the other thing that happens here is there's this extension fractures at the apex of the fold. So these extension fractures at the apex of the fold are, this is also, by the way, a lot of mineral deposits form this way. Development of stockworks, these vein systems, often they're associated with faults, but if you have a fold and a fault, this axial plane extension fractures, that's where the high grade ore is in mineral deposits. So you basically have these discontinuous extension fractures along the axial plane of the fold. And then because of the shear, you also have these AC joints, which are penetrative. They go through the whole fold, and they provide additional avenues for porosity and permeability. So what I was doing at this time is saying, okay, so fractures, we got fractures, and we got fractures. So let's make fractures the limit of the trap, and we'll make the whole basin a KGS. So I wrote this up in a couple papers in 1988 that went into the San Joaquin Geological Society proceedings. And the purpose for me putting those in there was to kind of lay a foundation for this moving on to this basin-wide KGS classification. But just in a general way, you got to think about this in terms of you got turbidites and the shale, right? So you got the Antelope Shale, basically, and these Stevens type sands, these turbidites. The really good sandy part of the turbidite behaves one way, the proximal parts of that turbidite another way, and then you get into the silicious shales and then the non-silicious shales. So this diagram just shows the difference in general response to drilling at those particular targets in depth, and you get a lot more production at shallow than at deep, because the deep are tight, and what happens there is that there's plastic behavior of these fractures at depth, and the plastic nature of the material just takes over. So the fractures actually, they're not really brittle, and they breathe, they change shape. So you have a fracture. This is what I think happened in that Portugal well. You had these fractures. They sat there for 6 months. The pressure built up 6,000 psi. So you jack open these fractures with the high pressure. That allows for the segregation of the oil in the water, and then you produce it. And then the fracture collapses, and there's no sand grain there to keep it from collapsing. So eventually it waters out. But you leave it there long enough and it'll repeat the cycle. Now, from an economic point of view, it may not work very well, because time's money, and the amount that you get off won't pay for a $2 million well, because it only works at deep wells. But my argument was, well, my God, guys, you already spent $3 million in the well. Why abandon it? Why not just put an automatic timer in the pressure there and let it build up and release and build up and release, like you do with a lot of the shallow sands? And you don't have to abandon it. It may not be a great rate of return, but you already sunk your money. Or maybe an independent come along and pick it up. But at any rate, that was the theory. So this is the map of the Geologic Survey analysis of these fracture plays. They made a distinction between the Tambor play and the Santos play. But what I was proposing was, we're going to make all that land known geologic structure, and then we're going to lease it competitively. Well, it was a great theory, and you lose some and you win some. But what happened was, this Ken Holden was the reviewer on this thing up there, and he, being an engineer, I guess didn't see the truth the way I saw it. So they never approved my report for the KGS classification. The law was changed. We still have some, the BLM still has 40 or 50 or so leases left to be classified. Anyway, it was good while it lasted. So I go off into the sunset. And after that program came to an end, I changed my ways to the mining division, and then I ended up appraising mining deposits throughout the state for the rest of my career. So that's my story.
Well, thanks, Greg. So if you guys have